Good afternoon, everyone. My name is Jeremy Herman. I'm an employment lawyer at Samfiru, Tumarkin, LLP, located in Toronto. It's great to be with you again. I've been hosting these live sessions for quite some time, and it's always enjoyable for me to answer your questions live. We have half an hour dedicated for that. So this is an anonymous process. Get your questions answered live. All those burning employment law questions that you want to ask, now is your opportunity to do so. And I will do my best to get through as many topics and questions as possible. As I usually start off by saying, we have offices across the country. We have two offices in Ontario and in Toronto and Ottawa, and we also have an office in Alberta, Calgary, Alberta, and Vancouver, British Columbia. So we're scattered across the country to ensure that we can assist all of you out there. So as I also usually do, I like to start off with an important topic just to get us going, and then we'll dive into questions. And so the topic that we'll start with is harassment at the workplace. Something we've spoken about before. It's an ongoing problem. It affects many Canadians. And so the question is, how do you deal with it? And to give you a story, a recent event that occurred in this situation, there was an employee who's an investment banker at Bank of Montreal, and this employee was subject to tons of harassment from other colleagues. The harassment occurred in person, it occurred virtually, really some terrible stuff that was said, homophobic slurs. And so the question from a legal perspective is, one, is the harassment allowed? And we'll get into that in a minute. The answer is absolutely not. But the question also that's important to ask is, can you be fired if you're the harasser, right? If you're someone who's harassing somebody else. A lot of the time we focus on the person being harassed and what their employment rights are. But what about that person who was the harasser? What are their employment rights? Can they be terminated? Are they owed severance? So if you were the harasser and you were terminated, typically you are owed severance. If you're terminated without cause, then you are owed a severance package. Okay? If you were told by your employer that as a result of the harassment that you imposed on somebody else, you were being terminated for cause, and therefore you're not entitled to a severance package, that may or may not be true. If it is true that there is evidence that you harassed somebody, your employer might be in the right there by terminating you for cause without severance. But perhaps it's just an allegation and it's not substantiated. There's no evidence that you've actually harassed anyone. You dispute that. Maybe you say that person harassed you. Every situation is obviously different. It's very contextual. But the point is that if you're terminated without cause, you're owed severance. If you're terminated with cause, you might still be owed severance, even though your employer is saying that they're not giving it to you. So please contact us. You can contact us at help@employmentlawyer.ca. We will help you determine if you're owed severance, okay? And that is really focusing on the harasser or the alleged harasser. Now, what about the harassee, the person who was harassed? What are their rights? So certainly you should not be harassed in the workplace. If your employer does nothing about it and they know about it, that is a breach of health and safety legislation. And it is also potentially a termination of your employment. So you also could treat that harassment. And if your employer, again, does nothing about it and they're well aware of it, you can treat that as a termination of your employment, and you can pursue the exact severance pay that you would be entitled to otherwise. Okay. And potentially there is other grounds. There might be human rights allegations that can be made because if, like in the case of the investment banker from Bank of Montreal, that person might be able to say that there's a human rights violation based on the harassment that he experienced. So you have a lot of rights. if you're the harassee for sure, and even if you're the harasser. It's a very important topic, like I said. It's all over the country, all over the world, in employment workplaces. So contact us and we'll help you figure out what your entitlements and what your rights are in that situation. And if you have any questions about what I just spoke about, obviously, please feel free to post it in the chat and we will deal with them. So that's the important topic that I want to start with today. Now, as promised, let us dive into some questions. So we have a question on YouTube from Sir. What is the formula for paid vacations? I came back to business after the lockdown. What are my entitlements for paid time off? What other time off are there in a leave of absence? Break times. Okay, so obviously this is a big topic. We will be able to touch on it. You are entitled to vacation pay. Okay, we'll focus on Ontario. You are entitled to vacation pay and vacation time. They are distinct topics. Vacation time and vacation pay, that is, but you are entitled to it. So in terms of vacation pay, what the Employment Standards Act says in Ontario is that you are entitled to 4% of paid vacation. So 4% of your earnings has to be calculated for vacation pay. And then after 5 years of employment, you're entitled to 6%. Okay. So I hope that answers the question, sir. And if there's any follow-up, let us know. But they are absolutely entitlements. Okay, vacation is an entitlement, and it's also important to note if you were terminated, you have to be paid out your accrued vacation, and you also would be paid vacation pay on the severance. Okay, so on the severance you obtain, vacation pay would be a percentage of that on top of the actual severance pay. Okay, so it's like I said, it's a pretty in-depth topic, but a very important one. And as you see on the screen throughout the session so far, we have tons of information on this. Check out employmentlawyer.ca. You will find tons of information, as I said, on these topics, on harassment, on vacation pay, etc. Okay, let's move on to the next question. So we have a question from Brian. Can a company restructure, let almost everyone in a department go, pay the people that were let go severance, and then give the one person left everyone's job responsibilities without an increase to their salary? Good question. And we see these all the time, situations of restructuring, of mass terminations as a result of restructuring. And as you said, Brian, those individuals who are terminated for whatever reason, if it's a without cause termination, the default type of termination, you are owed your severance pay. And then if there is someone left over, one person or several people in the department, and now for some reason they're being tasked with doing everyone's responsibilities who left, there's no obligation on your employer to give you a salary increase. However, if your job significantly changes in that you are now being tasked, like I said, to do all of these responsibilities that did not form part of your job description, then you can treat that as a termination of your employment as well. That would be a constructive dismissal. A constructive dismissal is where your employer is significantly changing fundamental terms of your employment without your consent and without an employment contract that allows them to do so. So there could be situations where your employment contract does allow your employer to change aspects of your employment, like your hours or your pay or your duties, and then you would not be able to pursue a termination or a constructive dismissal case against your employer because your contract allows your employer to do that. But in many cases, the contract does not allow the employer to do that, and therefore those significant changes that you do not agree to, like in Brian's case, a significant increase in Brian's duties, that you can treat as a termination. You would resign your employment and you would pursue your full severance pay. Of course, do not do that without first consulting with us. It has to be done properly. So please ensure that you contact us again at help@employmentlawyer.ca, and we'll help you with these issues, Brian, and how to navigate it properly. So Brian, I hope that helps, and feel free to post a follow-up. Okay. All right, let's move on to the next question we have on YouTube from Nathan. So Nathan says, I joined my company with an offer of 3 weeks of paid vacation. They've now switched to unlimited paid time off, PTO, which means I won't accrue vacation time anymore. Is this something I have to accept? So that's a good question, Nathan. And we're seeing unlimited paid time off become more and more popular because of people working from home, et cetera. After the pandemic, it kind of goes hand in hand, working from home and having potentially unlimited vacation. Obviously, so long as you get your work done. This is becoming a more popular model. So to answer your question, if it is considered a significant change to the terms of your employment, then you don't have to accept it. Okay. Again, it goes back to what I was explaining about a constructive dismissal. It could be that you can say, well, this is a significant change. I don't agree to it. I don't want this. I want the 3 weeks of paid vacation, and therefore I'm not agreeing to it. And if your employer continues to force it upon you, then you can proceed with a constructive dismissal claim. One thing to note, though, is that it's very important that the change that you are saying is imposed on you by your employer is significant. So Nathan, we should probably set up a consultation so that we can discuss that piece of it. Arguably, it would not be a significant change to the terms of your employment. That's what your employer might say. You would say otherwise, but it's something that we should discuss further. So feel free to reach out to us at help@employmentlawyer.ca, and we'll discuss the particular circumstances. Context matters. Why are they imposing the unlimited paid time off? Is it for everybody? Is it because you're working remotely, et cetera? So let's discuss all of those factors. Okay, moving on. We're getting a fair bit of questions today, which I'm pleased to see. We have one on Facebook from Sophia. I was just let go from a director position after 3 years. I'm nearing 60. I was only offered 2 weeks severance and continued benefits. This seems shockingly low of an offer. What can I do here? It is a very low offer, especially if you were nearing 60, like you said. You're in a director position. That's far too little severance. It potentially is not even enough to cover your minimum entitlements, which would be 1 week per year. And if you've worked there for more than 3 years, you would be entitled to minimally 3 weeks. So if they're only offering you 2, that's a problem. So Sophia, please contact us and we'll help you with this. You can do a lot here. Do not accept the severance offer. Make sure that you contact us before you accept anything, and we will help you negotiate a better package. This is what we are very skilled at doing. We do it every single day on behalf of clients, and we ensure that you get the severance that you're actually entitled to. So while I'm not so surprised, because employers do tend to do this very often, which is offer employees way too little severance, it doesn't mean that you don't have a recourse. Okay, so make sure that you contact us and we'll help you out. At this time, it would also be appropriate to talk about our Pocket Employment Lawyer tool. So the Pocket Employment Lawyer is a tool that we have. It's a free and anonymous tool, and it gives a wealth of information about employment law. And you can see it on the screen now, pocketemploymentlawyer.ca. Part of that Pocket Employment Lawyer is a severance pay calculator. The severance pay calculator is a tool, again, free and anonymous, for you to use to assess how much severance you would be entitled to, given your age, your length of service, your position, how much money you were earning. These are all the relevant factors for assessing how much severance you were owed. It is a contextual subjective analysis. It depends on your situation. And our pocket employment lawyer and the severance pay calculator allows you to determine what those entitlements are. Okay, so you'd fill in all the information and you can determine how much severance you're owed. It will tell you instantly the range that you are entitled to based on the information you give it. And I encourage everyone to use the tool. It's free and anonymous. You don't have to have been terminated to use it. So check it out. If you have been terminated, certainly use it. If you haven't been terminated, but you suspect that you might be, or even if you don't suspect that you'll be terminated, check out the severance pay calculator and the pocket employment lawyer tool and find out the entitlements that you have. So Sophia, before we even arrange a consultation, that might be something you want to do. You want to check out your entitlements on the severance pay calculator, and then absolutely call us and we will help you obtain the entitlements that the calculator tells you you have. Okay, let us move on. We have a question from Taylor on YouTube. Taylor asks, what happens if the employer fires an employee for cause or without severance pay based on bad performance? Great question. Very common. So we spoke about termination for cause at the beginning of this Q&A session. And we spoke about it in the context of harassment. And specifically, we were asking if you were the harasser, or your employer is alleging that you were the harasser, you've harassed another employee, are you entitled to severance? Can you be terminated for cause? And we said it depends. It depends on whether there's actual evidence that you harassed somebody. Maybe it's just an allegation. It's not true. And in that case, you would be entitled to severance. Taylor, in your case, bad performance. If you're terminated for cause due to bad performance and your employer says it was so bad, you're not entitled to your severance pay. In most cases, that is absolutely not true. It's just your employer trying to not have to pay you what they have to pay you. So unless it's extremely well documented, you were on a performance improvement plan and you just continued to fail to meet objectives, maybe in that case, potentially your employer would have a legal justification for terminating you for cause and without severance pay. But almost always that's not the case. And so please make sure that you contact us if you're in one of these situations. You're terminated due to bad performance with cause. Sometimes your employer is smart enough, and even though they might terminate you for bad performance, they are offering you your severance because they know that it's something that you are entitled to, and bad performance is not a good enough reason to hold that back from you. So it depends. But whether or not you were offered severance, you should still contact us, because it could be that you're not offered enough. Maybe your employer is telling you, we don't have to offer you anything because your performance was really poor, but we're going to help you out. We'll give you a couple weeks of severance. And in that case, it may very well be that you're entitled to much more than that. Okay, so please make sure that you contact us and we'll help you in that case. Let us move on now. And Taylor, if you have a follow-up, please feel free to ask it. Okay, we have a question from Kimberly on Facebook. At one point, can your employer refuse to accommodate you? I was told they were willing to provide accommodations temporarily, but couldn't do so long term. I'm waiting surgery and have no idea when my current medical condition will change or when I will recover completely. Okay, very good question, Kimberly. Generally, yes, your employer has to accommodate you. That's the law. We have human rights laws that say that. The human rights legislation in Ontario and across the country says that your employer has to accommodate you. And usually the standards, they have to accommodate you up to the point of undue hardship, which means there is a very high threshold for when your employer can say, we can no longer accommodate you. It's a very high threshold. So if your employer can accommodate you, even if it causes them some stress or some burden or it costs them money, it doesn't mean that they don't have to accommodate you. So telling you that they can only temporarily accommodate you, that's probably not good enough. It depends on why. It depends on why they cannot accommodate you long term. But in all likelihood, it is not a good enough reason. And if you are not accommodated, that is a breach of our human rights laws, and also potentially a constructive dismissal of your employment, in which case, as we've talked about, you would be entitled to your full severance pay. So even if you don't know your exact medical condition, you don't know when it will change, it doesn't mean that if there are accommodations that could be implemented, that your employer does not have to implement them. They do, in fact, have to implement those accommodations. Now, in these situations, it's very important to get medical documentation. You can't really say what accommodations you need. You can say it, but your employer will likely ask you that they need to see some sort of medical professional set out these accommodations. So is it that you need longer breaks, or is it that you're only working part-time, or you can't do certain duties? Maybe you're working in a very physically demanding job and you can't lift as heavy. These are common types of accommodations. In those situations, it's good to get them medically documented and, of course, provide that documentation to your employer so that they see that it is a recommendation from a medical professional that you have to be accommodated. The exact accommodations should be set out in that documentation, and then your employer absolutely has a right to accommodate you. Of course, your employer has to know about this. They can't accommodate you if they don't know. So if for example, some cases that come across my desk is an employee is overly burdened and stressed at work, and they're facing burnout, and they say that their employer is not accommodating them. Well, it could be that the employee didn't tell their employer what the accommodation needs to be, or it could be that they didn't tell their employer that they're facing burnout, and so that has to be done. Of course, your employer has to be well aware of it, and then at that point, absolutely, they would have to accommodate you. So. Kimberly, I hope that answers your question. Let's move on. We have a question from Barbara on Facebook. Is making staff return full-time to the office after working remotely for months a fundamental change? Would it be classified as a constructive dismissal? Great question. We're seeing this a lot. A lot of employees, especially around the pandemic, they started working remotely. And now or even a while ago, could have been up to a year ago, or now it might be, your employer is asking you to come back to work full-time or part-time. Could be that your employer is saying 2 days a week, 3 days a week. You get to choose which days. Sometimes your employer says you don't get to choose which days. Everyone's got to be in on Monday, Tuesday, and Wednesday, whatever the case might be. So are these fundamental changes? And so really it will depend on how long you worked remotely and what the reason for it was. So a great case would be a situation where an employee worked remotely, and even prior to the pandemic, that employee worked remotely and through the pandemic. And then now your employer is saying, you got to come back to work. We're making everyone come back to work. Well, that would certainly be a significant change, right, to a fundamental term of employment. The fundamental term is where you work, and the significant change is that now you have to come and work in the office, and you never had to do that, or for quite some time you didn't have to do that. So that would be a great case of a significant change, and yes, that would be a constructive dismissal, and you would be able to pursue your full severance pay. There are other situations. Maybe you've only worked remotely for a month or something. Maybe you only started working at the company a couple months ago, and you've worked remotely, or you've worked partially remotely, and now your employer's asking you to come back full-time, or maybe add a day that you got to be in the office. In those cases, it's difficult to say that it's a constructive dismissal. It very well may not be a significant change. It depends on how it was communicated to you that you're going to work remotely. Was it communicated as a permanent thing, or was it always expressed by the company that it's temporary. This might change. It could change soon, that we ask you to come back to work and work in office. All of these factors matter. So it's important that we arrange a consultation and get all of the details from you, because each case is different. But in short, Barbara, yes, it absolutely may be a constructive dismissal if you are being asked to come work in the office when you didn't have to before. Okay, let us move on to another question. We have one from Kathy on Facebook. Can a company make you put in paperwork to a third party to allow an accommodation? Great question. So this is not uncommon. You think, let's say, for example, you have some sort of disability and you need an accommodation, and your doctor writes you a letter, maybe your family doctor writes you a letter saying that you need a specific accommodation. You provide that to your employer, and your employer says, well, hold on, let us get it evaluated by a third party. Often that's called an independent medical evaluation. So in those situations, your employer should be accommodating you based on what your doctor says. Okay, there might be times where you should go on with the process and go with the third party accommodation. It could be that this is also now part of a short-term or long-term disability process, and which would also change the nature of all of this. So yes, sometimes you should go and you should go through the third party or the independent evaluation. But that doesn't change the fact that your doctor's note should be good enough, so long as it clearly sets out what the disability in that example is and what accommodation you need. But again, this does often play into a long-term or short-term disability claim. And so that does complicate things a little bit. And Kathy, I'd be happy to chat with you more about that. So you can contact us and we can arrange a call. So let's no problem, Kathy. Let's move on to Nathan. So Nathan asks on YouTube, my company recently announced return to office. Should I seek legal help before submitting a request for work from home accommodation? I have a recommendation from a medical professional. Is this enough on its own? It should be enough on its own. I mean, it could be that the doctor's note just simply says Nathan needs to work from home. Maybe the company will think that's not enough detail, and they'll want more detail as to why you need to work from home, Nathan. So yes, a consultation would probably be helpful, because we'll be able to navigate you through what the doctor's note needs to say, how you should broach the issue with your employer, all very important, and all has to be done properly and strategically, and obviously in accordance with the law. But your employer should be accommodating you if it's well documented, and if your doctor says that that's the accommodation that you need. Okay, we'll leave it there for today. We are pretty much out of time. We will be back, though, tomorrow. Like I said, we do these sessions all the time on a weekly basis. So join us tomorrow at 1 p.m. with my colleague Thielen, and he'll be here again live to answer all of your questions. It was great being with you. Take care, and I will be back with you soon.